All right. Very good. You on? All right, folks, this is 17 CI 00485. This is Mr. and Miss Held, Mr. and Miss Somerville versus the Walkers. We are present for what amounts to a final hearing in this case. Prior to starting the hearing, we had some discussions, and one of the topics of discussion was that neither defendant appears to be participating in this remote hearing. I'll let Mr. Baker address that. I don't believe there's been a request for me to, first off, I don't believe there's been any information that he's received that they are unable to attend or that they've asked him to get it moved. And I don't believe there's been any request to get it moved. I believe they were present when I scheduled the hearing back in early December. I issued a written order with the Zoom link in it. It is the same link that was used for the previous hearing. Mr. Baker, do you want to address any of that?
Not other than to just expand on that. Just a little bit, because I did send to the Walkers with a cover letter of December 21st, the order that this court entered that scheduled this hearing today. That order, I acknowledge, does have the Zoom link in it. And so they have been provided a copy of that order. And I have also attempted to reach them by telephone and email this morning. The telephone number that I used went to voicemail. I've not received a response to the email. So, Judge, we're prepared to proceed.
Thank you, sir. Mr. Pack, is there anything that you would like to say in that regard?
No, Your Honor. I think Mr. Baker has been very candid, and I appreciate that.
I agree with you. So moving forward, what I believe we should do, if I understand our off the record conversation, it is that what would be standing in the way of some sort of agreement in this case is a collection of maybe 3 issues that the Walkers had with the way things have gone over the last 2 years. And maybe going forward, those 3 issues were laid out by Mr. Baker. I think Mr. Pack addressed those, but I want to put those things on the record, and then we will talk about how I think conceivably we can resolve those issues.
Judge, to summarize our points that were iterated off the record into this proceeding, the Walkers first would be concerned with expanding the width of the driveway. The court has heard a lot of testimony at the original trial in this case about the configuration of the driveway, and that it is basically a narrow gravel surface that provides access to some private residences. They'd like to keep it that way. They do not want the width expanded. They don't want it to become a 2-lane road. They want it to be a narrow path basically through the woods to their house. The second the second issue is the fact that on Grace tells me that on frequent occasions, people who have been driving up and down the driveway just turn right or turn left off of the gravel surface and into the yard and into the field in order to turn around. And of course, they're opposed to that. They object to that. They don't want their yard or their woods to be used as a turnaround point. And then the third thing is that they have observed, and they described it on frequent occasions, the driveway being used. Mr. Pack made a reference to a racetrack. I'm not sure that I would I would go that far, but they use the driveway as a place to take their ATVs and or their golf carts for joyrides, and it creates a nuisance because of the proximity of the drive to the walker's residence. Those are our 3 points.
Thank you, sir. Mr. Pack, at this point, I think what I'm going to do as a preface to you addressing those is to transfer the host duty to you, because you maybe wanted to share some photographs. Other than, I guess I better make this clear. Other than you doing that, is it accurate to say that neither of you want to actually introduce anything in this hearing or put on any evidence, whether it's exhibit evidence or testimonial evidence?
Yeah, Your Honor, I was thinking about that. I think that you seeing the pictures was just to assist you. I don't know that I actually need to introduce them as an exhibit. I just want it. Sometimes I know you're like me, you just kind of want to see it to kind of help visualize what we're talking about. So that's really the only reason I had those pictures.
Yeah. And you're not, I mean, they will be part of the record in the sense that this is getting recorded, but they will not be exhibits in the sense that I am not A, formally introducing them, and B, in possession of a tangible photograph that would be marked.
Correct. And so I'll just make a very quick presentation, similar to what we did, just even quicker than what I did before we went on the record. So
go ahead.
All right. Have you made me host, Your Honor?
Yes, sir.
All right. First, I'll address the first concern, and let me go back down here to the beginning of the easement. I agree with Mr. Baker's position regarding the expansion of the width of the easement. The easement that was the express easement that's granted in the documents, my clients have no authority to expand that easement. It is what it is, nor do they have a desire. Unfortunately, what happens is that another party is doing the grading on the gravel road using a blade that does push the gravel to the side. And I'll see if I can find a picture that represents. You're starting to see here on the right of the picture where the gravel does build up. Over time, it will. If the Janes continue to use that blade, that gravel will get pushed over. We don't have a desire for that at all. But this gravel road does have to be graded because, as you will see coming up, there are depressions and little potholes that do come up over time. That's just the nature of the road. So it does need to be graded. There's no question about that. So what my clients are proposing is that, and I'll go, hopefully I'm not giving you all vertigo. Let me go quick here. The box grader to the left is owned by my clients. They're willing to do the grading and use that box grader and this other, now what was that called? It's
called a TR3.
A TR3 grader, which helps keep the rock within where it is. In other words, it doesn't push the rock to the side as like a snow plow would with snow. When you're plowing snow, it just goes and, to the side. These apparatuses keep the rock within that. And we really think if they will allow us to do the grading in that regards, it'll keep the easement as the size that it is. And I believe that'll address the walker's concern. The only tricky part about it is that the Janes are not a party to this lawsuit. They're doing the grading, and this court doesn't have jurisdiction to do anything, order them not to, so that's just, we can't do anything about that at this point, other than maybe the neighbors can talk to them and we can all just come to an agreement in that regard. So, but the good news is we're all on the same page. Let me go ahead and go to issue 3, which is the use of the vehicles. I can show you the vehicle that my clients use. Oftentimes on this easement, sometimes they use that to take the trash up or whatever they're going to do. There is a tractor that they actually use for the grading, which is right there to the right. Maybe a John Deere or a Cat, I'm not sure. they don't have any desire to use it as a, racetrack or anything like that. I will say this though, they have the right to ingress and egress. It's not uncommon that when kids are over, they'd love to get in these vehicles and drive them around. And that's not outside the scope of this easement if that were to happen. So I would caution the court regarding the third concern. As long as my clients are acting within the scope of the easement, staying on the easement, I don't think the court should limit the type of vehicle that should be on it that's within reason. We certainly understand that 18-wheelers do not need to be on this road because that's, it just, there's the bridge. We also do not want the bridge to fall in. So, in that regard, it's okay. But, as far as go-karts or ATVs, I think we're getting into a slippery slope if we try to identify what vehicles can and can't. And I certainly think the vehicles they have right now I don't see any problem with it myself, with the use of that vehicle right there. What my client's kind of whispering to me is when they go get the mail, they instead of getting in their car to drive up to check the mail at the road, they get into that ATV, which is, I'm sure it's once a day. I believe that's within the reasonable score. Yeah. So as far as the second issue, the turnaround, that one, I understand the walkers do not want anybody on their property. That's within their rights. And we obviously will talk to my clients about trying to limit or prevent that. The one thing we can't control are invitees or people who are just coming down the road who may have gotten lost. I could see where they might use their driveway or even our driveway as a 3-point turn to turn around. We all have that problem as homeowners, whether you live in the neighborhood or out in the county. So to some extent, we just have to, the law requires us just to put up with that to a limited extent. Obviously, if it's happening on a daily basis, that's another thing. I don't know that the walkers are saying it's that. I certainly will caution my clients to try to limit that or to eliminate it as far as they're concerned. We do not have control over third parties. So I'm not sure what else to say about the turnarounds. But, Your Honor, that's my position, and be happy to answer any questions you might have.
No, I don't have any. Well, I do have one. Mr. Baker, do you want a rebuttal?
No, sir. Thank you.
All right. All right. Let's look at these sequentially, and let me say that this is by way of just me making, I think, some observations right now. This won't be a final order, an oral order, because I'm going to do something in writing, and I'm possibly going to write something that might be different. And I'm going to address that in just a minute too, because I want to give you all the chance when I raise some of these issues or talk about some of them, that if you believe there's some pertinent law that I am not familiar with or don't acknowledge in this conversation, you could submit that to me. But first, I agree that the width of this roadway should not be widened. There may be some sort of very, de minimis angle there where, nobody's out there with a ruler saying it can't be a millimeter wider or anything like that. But I agree in principle with what the defendants are saying. And I think the plaintiffs agree with it too, that you don't need to take I'm trying to remember the dimensions of this, 16 feet or 12 feet. You don't need to take a 12-foot roadway and over time have it increase to a 16 or 18-foot roadway. That's just not what is contemplated in an easement. We talked a little bit about it originally 2 years ago, which is that the easement is not a general easement is an easement, and it's right pertinent to the land. It goes with the land, but it does not. It gives you the right to use it, but it doesn't give you the right to materially change it in the sense of expanding it. Right? There is a certain amount of, when you are the servient tenement, which the defendants are, there's a certain amount of inconvenience that comes with an easement. And having people use it to drive up and down through your property is one of those inconveniences. But by the same token, it's not supposed to be expanded to where the inconvenience is beyond what was contemplated when it was granted. So I don't think that's a problem. I agree with Mr. Pack that I can't control the behavior of a person or of persons that are not parties to the case. However, what I think I can say and probably will say with respect to that first point is in my judgment or order is that the easement should not be widened, and that one way that will be acceptable to the court to prevent that from happening is for the plaintiffs to use a box blade grading tool and a TR3 rake to maintain the condition of the gravel on the roadway and to keep the gravel from basically escaping on a permanent basis the historical dimensions of the easement. If they cannot convince this other fella to let them do it, which I don't know why. I mean, I don't know why a guy would want to grade if somebody else is willing to do it at their own expenditure. But be that, I don't know all these folks out there, so I don't know what, I mean, it is what it is. But if they cannot convince that guy to do it, then ultimately that'll just unfortunately be something that could come up in the future if, this, and again, for the sake of argument, we'll say it's 12 feet wide because I don't remember. But I mean, if this 12 foot wide easement in a year is 14 feet wide or 13 feet wide and defendants object to it and nobody will fix it, then it may just be something that gets brought up in the future. But I think that certainly what appears to be the preferable way and a way that would be acceptable to me would be what your clients, Mr. Pack, are proposing. But I agree that the defendants are justified in saying that they don't want that. That they don't want the easement to be widened. I don't think they're saying that they object to this box grading and all that. So it could be that won't ever be a problem. But I think that's probably how that issue is going to be addressed. The pull around or 3-point turning and all that. Again, I think the defendants are correct in this sense. I don't think we're talking about them cars pulling in, backing into one driveway and going back out on another driveway. I think what Mr. Baker's talking about is people leaving the roadway and going in the grass or going into the field or obviously they're not driving through a ditch, but driving into what would amount to somebody's yards, whether it's a wooded yard or a lawn type yard. And that is not consistent with the easement. Certainly, again, I don't think that it constitutes the crime of the century if there is a car that every now and once in a blue moon, the wheels, leave the road because you're passing somebody coming the other direction or whatever the case may be. But I think it is inappropriate under the scope of the easement for a car to be on that driveway and say, oh, I forgot my lunch money or whatever, and backing off into the yard and then turning back and going the other way. I think that's a violation. Now, the question is, who does that apply to? Obviously, it applies to the plaintiffs. I'm not sure, Mr. Pack, that I agree that they shouldn't be expected I'm not sure I agree that the people that they invite on the property aren't bound by it, because I think, you're kind of responsible for your guests. But I do think that obviously there's nothing you can do about it if some guy's driving down Finney Road and turns into the wrong place and, decides to turn around using somebody's driveway, which is, of course, or using somebody's yard, which is something that does happen. And obviously, you're only responsible for what you can exert control over. So I don't see how that could be laid at their feet. But, I do think that if you had, for example, regular deliveries or, I don't know what happens out there. UPS guy comes and he drives through the Walker's yard every time. I think that's something that should not happen. And, so I think I can adequately address that, and then we'll see how that turns out. But that's my thought on that. I guess really those don't seem to be really difficult to me. The most difficult one is the last one, which is, what comes up and down the road. I'm always a little bit cautious when I hear a slippery slope argument, because, I had a logic class, and the slippery slope falls in the fallacy category. So it is called a fallacy for a reason, that it's the slippery slope fallacy, not the slippery slope approach to life. But I think the answer here is that I don't think I have any authority to tell the people who benefit from the easement, you can use it to come in and out of your property, but only using a vehicle that doesn't make very much noise, or you can only go to your house and leave your house twice a day, or 3 times a day, or whatever. I mean, I think that ingress and egress is, nobody can tell me how many times I can go in and out of my driveway. And I think that it's pretty much the same thing, as long as they are using that to go in and out of their property. I don't think I can really control, and I've struggled a little bit with that. And that's kind of the main one that you all may have something that there may be a case somewhere, and I don't know about it. I haven't researched, I didn't even know that was going to be an issue really till we started talking. But there may be a case somewhere that says, hey, listen, just because you can go in and out to your house doesn't mean that you can drive up and down the road that's not necessary to go in and out of your house. I don't know. But to me, it would seem like that, there's nothing illegal about it. And if my memory serves, you're allowed to use a general easement for any legal purpose, any purpose that's not illegal. And as long as you're not unnecessarily offending the servient tenement. Now, the noise may factor into that. I don't remember there being any cases that say that. So if you all, especially, I guess, Mr. Baker, if you find something that says that, I will listen. I'm not going to get this done in the immediate future anyway, but because you already have a temporary injunction that's solving your immediate issues, but I don't want everybody to rely on that forever. So I do agree that it needs to be converted into something permanent. But if you want a week or something like that to submit something to me, I'm not going to hold it against you if you don't, but because I'm going to do my own looking anyway, but 2 sets of eyes are better than one most of the time. But at the end of the day, I think where we are on that one is that, again, I don't think that 4-wheelers or side-by-sides or razors or anything like that ought to be going off into the woods, ought to be churning up the grass, any of those things. But I think, for example, if you hop in your gator or whatever, you've got your razor, and you fly up there to your mailbox and then back, I do not think that is an inappropriate use of a general ingress and egress easement. And I don't think I would really have any basis in the law to control that or try to exert control over that. But I do believe that, I guess under the principle of just being good neighbors, it's something that might be a good idea to use discretion when you're doing that. But I'm not sure that that I can force other people to use discretion. I mean, you know what I'm saying? I think that, what I would like to say is, there's behavior or whatever that is going to be a problem. And sometimes it's just necessary to do, or more or less necessary. Other times, you're just doing it because you can, and that's not conducive really to keeping the dust settled. So the first part, I think I can exert some control over, which is what are you allowed to do. But what you should do, I think it just has to be left to every man or woman and their conscience, right? So in that respect, my gut is that I probably cannot tell them they can't use four-wheelers or anything like that, as long as they're not damaging. Now, I mean, we all, I think probably, I've been on my share of razors and four-wheelers and all that. And I mean, you could get out there and tear a gravel road up, and that would not be allowed. If that's the problem, then, as long as you're not damaging the road or throwing gravel all over the yard or all that, which I think maybe I could put in the order, you can't do that. But just to use it to drive on, I don't think I can dictate what vehicle they use to drive up and down the roadway, as long as they're not breaking the law in some other respect. I think that addresses all three of the concerns. I don't know. I will be happy to hear from either one of you. And I guess, Mr. Baker, you were going first before. So if you want to go first here.
Judge, I think everybody, to include me and opposing counsel in the court, have an understanding of the issues and an appreciation for the concerns. So I don't think I have anything else. Thank you.
All right, sir. Mr. Pack, anything from you?
I would agree with Mr. Baker's comments. The only thing I would add is just make a note on your order to refund the bond to my client. So if when you do your final order, if you'll put in there to allow the clerk to refund the $2,500 the bond to them, then that'll help us.
Yeah. Hey, one other thing I think I wanted to address was when this temporary thing went into effect, was that filed in the circuit or in the county clerk?
Oh, you mean a lis pendens?
Yes.
Or
Well, just the order, the temporary injunction order.
I don't know the answer to that, to be honest.
I don't recall. Yeah, I don't recall recording it with the county clerk.
Okay.
I will double check to make sure I haven't. If I did, I'll prepare a document that, well, I don't think I did. I'm almost certain.
Right. The only reason I was bringing it up is because I would think that maybe if you had, you would want to be conscious of maybe
Right.
filing whatever this final judgment is, so that the temporary one, so that nobody would look at a real estate record at some point and think that was still in effect.
Right. No, I got you. I'll give some thought about that.
I won't address that in the order because I don't know whether it was filed or not, or even whether a lis pendens was obviously, that would need to be addressed too. But since I don't know whether that was filed, I will leave that up to you to do it.
All right.
If it's germane. Okay.
Okay. Thank you, Your Honor.
All right. Anything else from either one of you today?
No, sir. Thank you.
I think
Okay.
I appreciate your words, Your Honor.
All right. I don't know who's just joined my meeting. It says James.
Hello,
Hi, how are you?
Judge. I was just trying to set this thing up. We have a meeting on Monday, and I'm just trying to figure out what it's doing and how to do it.
Oh, okay. Well, if you do what you just did today, but you do it on Monday at the time of your hearing, you ought to be there because it worked.
Well, I'm glad to know that, Your Honor. I didn't mean to interrupt your proceedings, but yes, we have a 9:00 meeting on Monday, and I'm kind of mentally challenged when it comes to these things. So I just try to get things set up so I wouldn't be not able to do it on Monday morning.
Understand.
All right, well, Your Honor, I'll get up out of here and let you go on about your business. And I appreciate you.
All righty. Thank you.
Thank you, sir.
All right, folks, if there is nothing else, then we will conclude our hearing. Thank you.
All right. Thank you, Your Honor.